Hello everyone, let's start the study here for chapter Free Consent. The index of this chapter, we'll study here 3 points one by one. First we will make a meaning of free consent, then we will try to get the point that what are the types of free consent, and finally at the end we will have a study in detail about various essentials of free consent. So first point is we need to understand what is the meaning of free consent. As you all know, consent means acceptance. Consent or acceptance both you always require at the time of agreement. Agreement is the preliminary stage of any contract. First we do agreement, and if suppose that agreement is a legal agreement, then it will convert into a contract. So in case of agreement, first any person used to give a proposal to next party, and if suppose next party is accepting that proposal, then it will known as an agreement. So acceptance is an essential part of any agreement, and if suppose this acceptance will be free, then it will be known as a valid acceptance. So consent is an essential element of an agreement, and even it always requires to convert the agreement into the contract. If suppose any agreement will be never exist if any proposal has not been accepted. So consent is the positive acceptance on the terms and condition of any proposal by that party to whom it was made. For example, if suppose there are two parties, one is Ram, one is Shyam. Ram has given a proposal to Shyam, and there are some terms and conditions over there. If suppose Shyam is ready to follow that all conditions, then it will known as particular acceptance of the proposal of Ram. Now, to make a contract valid, not only the consent is necessary, even it should also be free. As I said earlier that you always require an agreement, but that agreement should be always legal. If that agreement is not legal, it will never convert into law of contract. So for converting it into law of contract, you essentially require free consent as well as. For agreement you require a consent, but that consent should be always free, then it will convert into a law of contract. There is a difference or distinction in between a consent of contract and free consent of a contract. If consent is taken from some points which are restricted under law of contract, then it will known not as free consent. You always require consent which should be free, but if suppose you have taken consent from some points which have been restricted, and what are those points, we will later on discuss it in this chapter even. So if you have taken consent from these points, that points even, that will be not taken, that will not consider even as a free consent. So therefore there is a difference. You need consent, but that consent should be free, and when we will say that this is free consent, you require to leave some points in consent, then it will known as a free consent. Now we need to understand what are actually the essentials of free consent. In law of contract, consent is said to be free if it is not caused by any of the given items. As I said earlier that in law of contract there are few points has been given which are the restricted points. If you have taken any time consent from that points, then the consent will not be deemed as the free. That will be not free consent, and hence the conclusion is that agreement will never convert into the law of contract because it will be never deemed as a valid agreement. So what are those points? First are the point is coercion, second is undue influence, third is fraud, fourth is misrepresentation, and last one is the mistake. So remember always students, if anytime anywhere if you have taken consent anyone from these 5 items from the next party, so your consent will be never deemed as the free consent, and it will be never a legal agreement, and it will be never convert into the law of agreement. Therefore we used to say at the time that all agreements are not contract, but all contracts are agreement, because this agreement will never convert into the contract. Now we will study one by one these points. What is actually coercion, undue influences, mistake, mispresentation and fraud. So I'm going to start here with the first point, coercion. What is coercion? Coercion is actually the committing or threatening to commit any act which is unlawful. This is actually the pure definition of coercion. Coercion means if you have done something unlawful, or even if suppose you are giving a threatening to do some unlawful activities to the next party. The question is why you are doing unlawful or why you are giving threatening to do unlawful. The reason behind it just because you wanted to take the consent anyhow or acceptance anyhow from the next party. Means you want to take him in an agreement as a party of the contract. Therefore, you are doing something wrong. Either you are just going to give a threat to do something wrong. Examples. After giving a good beating to A, B makes him to agree to sign a promissory note of rupees 1000. Again, you can take it in a different example. Suppose Ram has given a proposal to Sham, but Ram is giving some unlawful threatening to Sham or doing some unlawful activities against the Sham, and particularly he is doing this all just to take him and the contract or just going to induce him to do this, because if suppose he will not do, then something will be against him. So this is what all Ram is doing known as unlawful, and if suppose Sham is giving his consent on behalf of these activities, then it will be never deemed as Sham's free consent. What are the types of coercion? How we will say that this is actually coercion? If suppose anyone is giving a threat to file a suit against anyone, this is also type of a coercion. Ram is giving a threatening to Sham that he will just make a claim against you in the judicial, and if suppose Sham is feeling insecure due to that threatening and he is giving his consent, then it is also type of a coercion done by the Ram against the Sham. Second is, suppose threat to act some unlawful acts. As I said earlier, this is actually the basic definition of the coercion. If anyone is doing anything unlawful against the party to take his consent, purely comes under the definition of coercion. Third one is threat to detain the property of any person. If suppose one party is giving a threat to just take the possession of the property of any other party, and he's again doing that to make him particular insecure, and from that he will be giving his consent, and this is his purpose, so it is also comes under the category of coercion. And fourth, which is the last type of coercion, is that if anyone is giving again any kind of threat to take a suicide step, also comes under the category of coercion. So these are fourth kind of types. One is if suppose the threat to file a suit. Second is if suppose threat to do some unlawful, and if suppose you are just going to give a threat to detain the property of anyone, which is purely illegal. And fourth is if you are doing some emotional activities, you are just going to bind with the emotional pressure, either you are going to just give a just kind of threat to make a suicide step, all comes under the category of coercion. Now, what are the essentials of coercion? 3 points, you can take it one by one as an essentials. First, the act must have been done with an intention of causing any person to enter into an agreement. This is purely an illegal intention which one person was having with him. Therefore, he had given a threatening to another party because he actually wanted to take himself and as the party of the agreement. He wanted to take acceptance or consent of that party. Therefore, he had done that. Second point, coercion can be applied either by a party to the contract or even by a stranger. So this is also very important point and an interesting point, that this is not always required that only the parties to contract they can do coercion. If any stranger, he is not the part of the contract, he can do also something on behalf of anyone else against the party from whom he is actually willing to take the consent. So it doesn't require that only the parties can do the coercion. Some stranger can do also coercion on behalf of any party to contract. Third point is, it may applied against a party to the contract or maybe some other person. As I said in the point number 2 that coercion can be done by the parties or by the strangers. Same thing applicable in the point number 3rd. Coercion can be applicable against the party of the contract or can be applicable against the stranger. For example, suppose there are two parties, one is A, one is B. A can do coercion against the B to take his consent, and parallelly A can appoint any stranger to do same against the B to get B's acceptance. And point number third specifies that A can do against the B as well as against any relative, any close person of the B to just again induce the AB to give his consent. So coercion can be done by the party or can be done by the party just against the party as well as, and a stranger can be applicable in both the cases. Now we will study what are the effects of coercion. When the consent of a party to an agreement is obtained by coercion, this kind of agreement will be known as the voidable agreement, or this kind of contract become as voidable contract. Voidable is a technical jargon over here, and it says that this contract will be only applicable or only executed by the law if suppose the victim party is ready to enforce it. And in this case, the burden of proving that the consent was not free, it is on the shoulder of the victim. If suppose A has taken wrong consent of B and it was just due to the pressure of coercion, then now this is the duty of B to prove it that he has not given his free consent, he was actually binded due to the physical pressure or some kind of threatening. Now we will study the second point, what is the meaning of undue influences. Students, as I said earlier, that you require consent to make an agreement, and parallelly you require free consent to convert that agreement into a contract. And how you will say that this consent is free or not? There are basically 5 points. One we had discussed already, that was coercion. Now we are going to study undue influences. After it there will be mistake, fraud and misrepresentation. So what is undue influences? As it is clear by their name that some person is carrying some kind of influences which are having a weightage with them. So undue influences is the improper use of any power possessed over the mind of the contracting party. If suppose there are two parties, one is A, one is B, A is a teacher, B is a student. So definitely there is a relationship exists between them where A is dominating. A can use his power just if suppose only for his purpose as well as for the next purpose. So if suppose he's using that powers for his some kind of other activities, it is known as undue influences. A contract is said to be affected by undue influences in following two cases: when one party is having the power to dominate something, and secondly suppose he is using his power to obtain some unfair advantage. As I said earlier, there were two parties, one was A, one was B. A was a teacher, B was a student. If suppose A had just used his power to get some unfair advantage from the B, and therefore B was actually ready to pay him because he was his teacher, and this is actually known as undue influences. Means B was actually not in case to give his pure consent, he was actually having the impression of A's personality, therefore he had given. So this is known as undue influence. Again, undue influence continue over here. In following three cases, law presume that a person to be in a position to dominate the will of another party. These are 3 points where law itself assumed that one party was in the power to just make the changes in the opinion of the next party, particular for acceptance of the proposal. First is where one person holds a real authority over the other. For example, if there is a relationship between servant and master, child and parents. So in these two cases always you will realize that one party was having the real authority against the second party. Servant has no right. Whatever master has been just giving to him, he has to follow that same. Same thing in the case of children and parents. Whatever has been just imposing by the parents, children has to do the same. So in these two cases always you will feel that one party is having the authority to make the changes in the opinion of the second party. Secondly, where one party stands in a fiduciary relationship, like the relationship between the religious guru and their followers, relationship between the beneficiary and the trustees, relationship between the doctor and the patient, and relationship like the lawyer and the client. In these all cases, we will see that there are some kind of fiduciary relationship exist, where one party is having an impression of the other party's relationship. Like if suppose A is a patient and B is a doctor, so whatever B is telling to A is actually, kind of having an impression to follow the same, because they are having fiduciary relationship. And third is where one person makes a contract with another person whose mental capacity is temporarily or permanently affected due to some reasons like age, like illness, or like mentally distress. So in this case also you can understand that second party is having incapacity to just make a decision, so he is actually incapable to understand what he is going to do. So therefore his consent will be never just deemed as free consent, because he was not able to understand the positive points or negative points. He was not able to take the rational judgments there. Now for continue, who is actually proof give that this his consent was not actually pure, and if suppose it was taken just by undue influence. To prove that the consent has been affected by the undue influence, all the three essentials which we discussed in the last slide must be proved in the same sequence. Means the victim has to prove us that like he was in the real authority or not, he was in the fiduciary relation or not, or his mental capacity was fit or not. First 3 points you need to categorically prove. If suppose you have been proved first 3 points, then definitely it will be automatically taken that this consent was not taken by the one party as free consent from the next party, until unless if suppose this will not prove, this will be a valid proposal. If it will prove, it will be just deemed as a voidable deal, and voidable deal means execution of this deal will depend on the party's choice who had given not his free consent. Now, what is the effect of undue influence? An agreement caused by undue influences shall be voidable, and it will just depend on the opinion of the party who has not given his free consent about the execution of this deal. Now, we will study what is the difference between a coercion and undue influences. There are basically 3 points we will study on this slide. First is the type of force. In case of coercion, always you will see that physical force is exercised, but in case of undue influence, the moral force will be exercised. Because in case of coercion, either you can just use some threatening or you can just do some unlawful activities where definitely physical involvement will come. But in case of undue influences, you will only change the mindset about the opinion of the next party, because you will be definitely doing the dominating in the case. You will have some real authority, you will have some fiduciary relation, or you will be definitely knowing that the second party is not having the capacity to understand. So moral force will be using definitely in case of undue influences, and physical force will be activated in case of the coercion. Second point is mode of obtaining consent. In both coercion and undue influence, the consent of the aggrieved party is not free. As we know, this is the similarity between them. It will be never known as a free consent in both the cases. But in the case of coercion, the consent of the aggrieved party is taken care by giving him threat or doing something unlawful. But in case of undue influence, you will never do some unlawful, you will never give any kind of threatening, you will only use your position just to obtain some unfair advantage. Third is the existence of the relationship. In case of coercion, the relationship between the parties always does not even require. This is not always mandatorily required that the party is giving the threat to the next party. It can be done by the stranger as well as, and it can be given to the stranger as well as. So the relationship does not require to be existed in case of the coercion, but in case of undue influences, always relationship must require. And remember, undue influences is actually all and all the game of the relationship, where one party was having the high power in the relationship. Due to that, he actually dominated and he used some unfair advantage from his position. Next is third point we are going to discuss over here. What is the meaning of misrepresentation? Misrepresentation is actually the false representation which was made innocently by one party to the next party, and if suppose next party has believed on that false representation and he had given his consent, so it will known as not free consent. So mispresentation is the third point. First we had already covered first 2 points, which was they were actually coercion and just undue influences. So what is mispresentation means? One party is giving false representation, but this is not actually intentionally representation. This was done by innocently by one party. It may include the following 2 points: wrong statement of a material fact which is not known to be false. If suppose one party has given some facts which was essentially to speak, but whatever he told that was wrong, and he was not actually able to just understand it that he is going to speak wrong. And secondly, non-disclosure of facts without an intention to give a deceive where the legal duty is to disclose. If suppose there was a duty of one party to speak something in case of proposal, but he didn't speak, and he was not knowing that if suppose he is not speaking, he will be just going to ditch something. So he had no any bad intention, but he has not spoken something, so it will be also taken as mispresentation. Means if you had told something wrong which was not knowing by you as wrong, and secondly if you have not told something which was your duty to speak, but it was both thing you have done by actually innocently. In mispresentation, the knowledge or beliefs in particular facts is never based on reasonable grounds. This is also very important point over here. Now what are the examples of mispresentation? Just suppose A, who is about to sell his horse to B, says my horse is sound, and at that time A doesn't know that the horse has fallen ill even yesterday, and B thereupon buys the horse. So it is actually mispresentation done by the A, because A was not knowing that his horse was not well, and he actually committed that his horse is in the sound position. So whatever was told by the A to B, and B actually just supposed belief on the actual facts of the A, and he actually made a deal. So here B's consent will be not taken as a free consent, but here A's part will be actually taken care as mispresentation, because whatever was told by the A, that will be taken care by innocently. Mispresentation may be committed in any of the following ways. You can commit it by positive statement, you can commit it by breach of duties, or you can do it by any kind of innocent mistake. So 3 points are always you require to do mispresentation. Now what are the effects of mispresentation? Innocent mispresentation is actually knowing as just telling the wrong facts of any material knowledge to the aggrieved party. So this kind of deal will be always known as the voidable deal. Means again here judicial will ask to the victim party just to execute the deal or not. If the victim party is willing to execute the deal, then it will be applicable, otherwise it will be known as the void. And parallelly, aggrieved party has also a right to make a claim for the damage as well as. So here 2 things aggrieved party will obtain. First, for the execution of deal he has the right to say yes or no, and secondly he can make a claim against the party who made the mispresentation to him, and due to that he had given his consent. Now the next point is fraud. Fraud is actually the condition of intentional mispresentation. In case of mispresentation, you just have studied that was innocent mistake, but fraud is actually intentional mistake, because you have done it just to give a deceive to the next party. Fraud includes any of the following facts, like number 1, if suppose any suggestion which you had given as a fact and you were knowing that this is not true. Secondly, if you have made any promise without any intention of performing it. Third is if you have done something which is known as deceive. And fourth is any such act or omission of anything which is specifically known as the fraud in any law. So 4 point always you require in case of fraud. First, for example, if you are putting any suggestion to anyone and you are knowing that this suggestion is not actually true, and you are giving a pressure to follow that suggestion as a true to the next party. And secondly, if you are making a promise and you are knowing that you are never going to just follow the promise, so without any intention you are giving a promise, will come under the category of fraud. And third point is that if you are doing something which is just generally known as fraud. And fourth thing, if you have done something or you have omitted something as per the part of the law which will known as the actually fraud.